Days after Nupur Sharma had engaged in a debate on a TV show and had made certain comments and multiple FIRs were registered against her, today the Supreme Court of India has granted her a big relief, clubbing all those FIRs and sending them to the national capital. In fact, the court has also entrusted the Delhi Police Special Cells IFSC unit, that is the Intelligence Fusion and Strategic Operations Unit of the Special Cell, to investigate all of the cases registered against Nupur Sharma, and has in fact also directed that all the future FIRs would be clubbed and would be investigated by the special cell itself. Now, I have with me a very special guest, Advocate Ashwini Dubey, who's one of prominent lawyers in the Supreme Court and has been a very keen person in criminal jurisprudence, knows the criminal law for a very long time. Welcome to the show, Ashwini sir. Welcome to CNN News 18. Sir, my first and foremost question to you is, how do you react to the orders that have come in from Justice Suryakant and Justice J.B. Pardiwala, the same bench which had criticized her for her statements and in fact blamed her for the Udaipur killing itself?
Thank you, Ananya, for having me here. Ananya, the rule of law has been established. The Supreme Court have established the rule of law, and the previous precedents which have been passed by the Supreme Court in a similarly placed cases where the various FIRs, multiple FIRs on the same cause of action has been instituted at different places, different locations. So the Supreme Court has done, in fact, by clubbing and by making an order, giving an order that no coercive action should be taken, has in fact given a big relief so far as the fundamental question which was before the court, big relief so far as the person right to life and liberty, which has been extensively discussed in Article 21, right to life, and also in consonance with the Article 20, sub-article 2 of the clause 2 of the Constitution of India, which says that the person for one cause of action for multiple FIRs, he should not be punished, and also keeping it with the Article 300 CRPC, which prohibits the double jeopardy. Yes,
so,
over to you.
A very critical order coming in, a very detailed order, in fact, coming in from Justice Suryakant and Justice J.B. Pardiwala, and it's the same bench which had said that she's a loose tongue, she is responsible for the Udaipur killings. How do you see this change of mind, and what do you think has led to, in fact, this change of mind that has come across?
Supreme Court, in fact, Ananya, is the custodian of the Constitution. At a time when Nupur Sharma initially approached the Honorable Supreme Court, and it's July 1st, 2022 order on, there were certain materials which were not placed before the Honorable Supreme Court. The Supreme Court, in fact, has not dismissed the plea of Nupur Sharma, in fact, has asked to approach to the High Court. Subsequently, when various threats were issued, when the killings in Udaipur took place, when one Chishti allegedly issued a video for beheading the Nupur Sharma, when other persons in some Aurangabad of Maharashtra, some incidents took place, and many other incidents took place, and which were brought in the notice of the Honorable Supreme Court, that it is not only right to the life of the Nupur Sharma is in danger, but various other persons are also instituting many cases, and the state is patronizing it. So multiple FIRs in West Bengal, multiple FIRs in Maharashtra, multiple FIRs in Kerala. So Honorable Supreme Court took it, and on 19th July order passed the order. So it is very well within the domain of the Honorable Supreme Court, also power given by the Constitution to the Supreme Court may pass this kind of order. So it is also that the rule of law was not ignored. In fact, rule of law was established. So earlier order where the Honorable Supreme Court could not reach to any conclusion, subsequently when it was brought to the Honorable Supreme Court passed that order. And today also, Honorable Supreme Court, by making an interim order saying that no coercive action shall be taken, and the first FIR shall be investigated, and rest of the FIRs will be tagged along with that, and Delhi High Court will look into the quashing issue, because quashing and clubbing both are different issues. And you would understand, you are very well-known legal journalist of this country, you will understand that the clubbing of a fire is a different thing and quashing of fire is a different thing. So Honorable Supreme Court has asked Delhi High Court to look into it, and also the premier agency of this country will investigate the matter.
So, one thing for our viewers, very specifically, I'm asking you is that the cases of Mohammed Zubair were cited, the cases of Arnab Goswami's judgment was cited. what is the precedence in these cases, and how does the CRPC and the Supreme Court has dealt with cases of clubbing of FIRs earlier into in such matters when multiple FIRs are registered against a particular person?
Ananya, let's start it from the Keshwanand Bharti case. In Keshwanand landmark judgment, Keshwanand Bharti versus the state of Kerala, Honorable Supreme Court held the rule of law forms the basic structure of the constitution. And further, Ananya, you would recall that in IR Kolhe versus the state of Tamil Nadu, Supreme Court held the rule of law cannot be changed or abolished by the constitutional amendments. And this manifests the high status given to the principle in Indian constitutional jurisprudence. Subsequently, one of the landmark judgment which you just referred, the TT Antony versus the state of Kerala and Jubair's case, the Honorable Supreme Court held that filing of another FIR for the same cognizable offense, as has been alleged in the first, will be violative of Article 20, subclause 2 and Article 21 as well as Section 300 of CRPC. You just referred the Arnav Goswami's case. In the case of Arnav Goswami versus Union of India, following the same precedent, all the FIRs were clubbed in one place, and it was held if a court fails to do this, it would be violation of the petitioner's right as a citizen to fair treatment under Article 2014. And similarly, the Honorable Supreme Court in Jubair's case says the Constitution of India intends India to be a country governed by the rule of law. The courts are the enforcers of the law, and they must engage in impartial decision making free from any external influences. And in a democratic country like ours, access to justice forms the bedrock of this nation. So that there are the landmark cases, landmark judgment, and the Supreme Court has upheld the judicial system and the past precedents which are there in order to do the complete justice. Over to you. Ananya,
Another thing that really arises here is that many people, in fact, multiple FIRs or multiple FIRs is not something that has been very new in the CRPC or before the Supreme Court. But what had happened after Nupur Sharma's case was that there were people were divided into basically two minds. One was questioning the verdicts of the top court, while the other was supporting it. How do you see that and it's a very, very general question, that whether such kind of views from the public, do they actually affect the judges or not? That's something that a lot of people would like to know about.
In fact, judges are also human being, Ananya, and you practice and report for the top court of this country. Judges are also public servants, and if any selective agenda is run on the social media to tarnish the image of the institution or tarnish the image of the judges, then definitely it affects to them and their families. One. Second, selectively, if judgment is recently, what trend has started, Ananya, you would agree with me that recently, if judgment is not in favor of certain class of the people, they start criticizing the institution itself. But if judgment comes in their favor, then they say the rule of law has been upheld by the Supreme Court. But similarly, targeting the institution, tarnishing the image of the judges through social media, of course, is damaging the very, very big institutions, and the institutions which are known for their impartial view, institutions which are known for upholding the judicial system, which are known for custodian of the constitution. In Nupur Sharma's case, when that remark was made, in fact, I do agree with you and others also, if you cannot write something, then we should not make it. But that was not the way it was reported on through the social media, and the way public took it, that of course was a problem of worry, because it is not only concerned with the life and liberty and the right to life of the Nupur Sharma, but other persons also sacrificed their life. What happened when they posted the posters of Nupur Sharma supporting Nupur Sharma, then they were either the murder or the beaten, or they suffered the public outrage. So these are the things which is not good for the country, because we do not run by any fatwa court or any court Shariat law, but we run by the rule of law. There is a rule of law, and there are no kangaroo courts, but the courts established to the procedure. One. And the second, Ananya, when the state patronize the offenses, when state selectively misuse and abuse the provisions of the criminal law, then the courts come to rescue in favor of the person concerned whose right to life have been violated, and also the courts can upheld the Constitution of India and the right given to a person under the Constitution of India. So I think that the courts have done a tremendous job in past, also in Keshwanand Bharti's case, also in Sundarjas Bhatijas versus the state of Maharashtra, in ADM Jabalpur's case also, Zubair's case also, Rohit Ranjan's case also, Arnab Goswami's case also, and today also Honorable Supreme Court has upheld the majesty of the law.
Last and final question before I let you go, and before that, you remind me some words of Justice Krishna Dikshit while he was dealing with the hijab matters. He said that Constitution is like the Bhagavad Gita for us, and that's what we go by. That were actually the words. But before I let you go, the West Bengal government was basically arguing today before the top court that the maximum impact of Nupur Sharma's statement has remained in West Bengal. In fact, they also argued that a SIT should be set up into this particular case to investigate all these FIRs that've been there. So how do you see the stand of the West Bengal government before the topmost court? But the same was actually rejected by the topmost court of the country at the end of the day.
The law sees the test of sameness on the basis of the first instituted FIR. And if first instituted FIR and the cause of action first time has arisen in Delhi, and the first FIR was registered in Delhi, which is being looked into by the investigating agency, that the multiple FIR will form part of that FIR. So the state of West Bengal, by making this attempt, was in fact trying to patronize the offenses which was registered by them on the basis of the various complaints received through various police stations. We should not forget that the state of West Bengal is the same place where the constitutional machineries and authorities were highly misused and abused, and there was a complete constitutional breakdown at a time when CBI had gone to investigate a matter in the case of the former police commissioner, Mr. Rajiv Kumar. Then the chief minister herself came in rescue of that police commission. It shows that there is fundamental question, fundamental law, and the basic law which talks about the federal structure of this country, as per which both the agencies and the union and the state should work in coordination with each other. That was lacking. So that was the problem of worry. And we as a human being, Nupur Sharma and other citizens, they all were worried about what will happen, the consequence, because process should not become punishment. Admittedly, a fire has been registered, that has to be taken to the logical conclusion, and that's the law also says. But the process should not be misused and it should not become punishment. This is the ultimate law. Yes, over to you.
Yes, definitely. The process should not become a punishment, is what exactly the Supreme Court has also been saying continuously. And we are seeing massive judgment coming in, clubbing of FIR, whether it's the case of Arnab Goswami, whether it's the case of, in fact, Nupur Sharma. And we recently saw in a connected matter, another journalist was given this relief. Now, the topmost court has, in fact, left us with a new judgment, with a new precedent where FIRs can be clubbed under the CRPC as well. But then continuously the matters like these are coming up before the courts. And Ashwini sir, very thankful to you to joining us for this broadcast. Supreme Court has given out a very clear verdict that the cases against Nupur Sharma are to be clubbed back to the national capital. The Delhi Police's SFIU unit, that is the Strategic Fusion and Intelligence Unit of the Special Cell of the Delhi Police, would in fact now be investigating the cases against Nupur Sharma, and all of the cases, whether it's in West Bengal, whether it's in Maharashtra, would now be investigated by the Delhi Police itself. And the Nupur Sharma can in fact knock the door of the Delhi High Court seeking any kind of relief or quashing of the FIRs that have been registered against her over her scandalous or controversial remarks against the Prophet. I'm Anand Bhatnagar for CNN News 18, signing off from the StreamYard.